Hello, and welcome back to Coin Lady channel. Today, I'd like to talk to you about three different things. The lawyer describes Ripple SEC settlement road amid Coinbase case impact is where I'll begin. One might think, wait a minute, didn't Ripple say they were super unwilling to settle? If only there was a path forward for XRP? Because you may be wondering why it is that Ripple does what they claim to do. That's what I'd want to explain in detail. Another news story caught my eye. Crypto basic expert says no IPO announcement or settlements at Ripple, upcoming XRP parties. As you may recall, or as some of you may not know, on July 13, 2023, XRP received legal clarity thanks to a decision from Judge Analisa Torres. Ripple is literally throwing a party in New York City to celebrate this day. It's fantastic that it's costless, and that they'll be serving a wide variety of complimentary refreshments. Is there going to be a real announcement, though? Or is it just a large group of folks who enjoy eating and drinking together? And then there's this, which has nothing to do with Ripple or XRP. However, I feel it's important to address this interesting but icky topic at the end of the video. The previous CEO of Alameda spent $2.5 million on a yacht and engaged in some shady boating activities, according to a court complaint obtained by Cointelegraph FTX. But before we go any further, I should state that I have zero experience in the financial sector. You shouldn't purchase or sell anything based on what I say, and I'm not a financial advisor. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. Okay, so under this first piece, there is hope that Ripple and the U.S. Securities and Exchange Commission can come to an agreement. Token sales on the Coinbase exchange would not be subject to U.S. securities laws if the judge grants the exchange's motion to dismiss, as advocated for by John Deaton, a lawyer representing numerous XRP token holders, in a separate lawsuit against the Securities and Exchange Commission. Crypto staking, however, would be excluded. Okay, but in a moment I'll demonstrate just what Attorney Dean said. But where did this begin? This XRP post seems to have been the catalyst. Community member Ashley asked an excellent question and provided the following response. I seem to recall that Ripple promised a fast settlement should the SEC rule that XRP is not a security. The legal system has spoken, and XRP itself is not considered a security. Even the SEC admits in its most recent court filing that XRP is not a security. To what extent, then, do the outstanding obstacles prohibit a settlement? That's pretty much right, I guess. Also, that's a really good inquiry. The Securities and Exchange Commission, SEC, has gone on record as saying, yeah, we actually are not going to appeal the idea of XRP not being a security. They advised passing judgment on Torres. Not going to experience that at all, thank goodness. Because they have already achieved their goal of having XRP classified as not a security, Ripple is now not settling. As compensation, that they would have coughed up the money for an absurdly high fine before trial. Nonetheless, there is less of a reason for Ripple to back down now that Judge Torres has issued a ruling on the application for summary judgment and given XRP itself legal certainty. In addition, the SEC submitted a legal brief to Judge Torres in which they explicitly said that they will not be appealing the ruling regarding XRP's legitimacy. If Ripple truly desired to soon go public through an initial public offering, IPO, that is the only thing I can think of that may lead to, some type of agreed upon settlement, and that would be a huge element. Can we please get this over with? Yeah. This initial public offering, IPO, simply cannot proceed without it. Although I'm sure you all can come up with anything, I'm at a loss as to why Ripple would be motivated to accomplish anything now that they have what they sought. Right? There will be resistance from Ripple to Judge Torres' order on institutional sales, but I think they got the lion's share. I believe it to be the correct conclusion. What Ashley Prosper posted on Twitter was retweeted by Attorney Deaton, or whatever the new term is. Here is what Deaton, the lawyer, had to say. Only if Judge Fila grants Coinbase's motion to dismiss or partially grants it in finding token sales on an exchange in a blind bid/ask transaction do not fall under U.S. securities laws, but allows the staking component to move forward, will Ripple and the SEC settle before the end of the year. The SEC and Gary Gensler could have to make a change if that occurs. The Solicitor General probably wouldn't let an appeal through in such situation, as it may end up before the Supreme Court, where the power of not only the SEC but of every other government agency would be significantly eroded. That brings up an important point, or points, in my opinion. I hope you'll share your opinions with me below. That, though, seems very reasonable to me. And then they elaborated on that thought. There will be no IPO statement concerning our settlement at the upcoming XRP party, according to the headline from a crypto fundamental specialist. It may take some time to adjust to the fact that X is now Twitter and that he just retweeted himself, along the lines of what I just told you. And now, the information that the lawyer withheld. In other words, I have no special knowledge. That being stated, I should probably let you know that there won't be any announcement of a settlement made at the Ripple actual party. Find out why I think that below. An initial public offering, IPO, announcement is also not expected. Who gets to say yes to an initial public offering? In the remedies phase of the litigation, the SEC is seeking a permanent injunction against Ripple. With respect to future institutional sales of XRP, and if they win at trial, they will also seek permanent injunctions against the CEO and chairman of the board. Therefore, I concur with his assessment. If there are major developments, then of course. What exactly that would be, I couldn't tell you. It's meant to be a party, that's all. So, if they have something neat, that's terrific, but don't expect an initial public offering. Before that party, you'd have the only fancy cylinder, because of how this works out. That, to me, is really mind-blowing. In my opinion, that is not the case. Right? That's probably not the case. No resolution means there will be no IPO updates. The ex-CEO of Alameda also spent $2.5 million on a yacht, according to a court file obtained by FTX. A series of financial papers published by FTX creditors show transactions that benefited firm officials just before the collapse of the major cryptocurrency exchanges in November 2022. A recent court filing with the United States Bankruptcy Court for the District of Delaware revealed several payments or property transfers executed within 1 year prior to the collapse of FTX that benefited senior company executives at FTX. In Alameda Research. Although FTX creditors have made every effort to ensure the accuracy and completeness of this information, they cannot be held liable for any mistakes that may have been made in its compilation. Come March of 2022. Alameda Research Company. CEO Sam Turbuka benefited from a $2.51 million transfer from the company to the American Yacht Group. In a tweet from August 2022, shortly after this deal was finalized, Turbuto informed his followers of his resignation and acknowledged his ownership of a boat. And so, images were released with a note, of course, that was just, I don't recall I don't know when it happened exactly. There is no significance to the month of August. That is to say, less than 3 months ago. All of this transpired in early November because FTX suddenly crashed. In any case, the ceasefire holds. Former co-CEO Caroline Ellison Alamitos replied to his message by wishing him well and asking that he spare her some more time aboard his boat. Several ex-FTX executives received cash payments in the 12 months leading up to the company's demise. These included Sam Bankman-Fried, and Gary Wang, a former FTX director of engineering, Rashid Singh, a former FTX chief marketing officer, and a former FTX chief operating officer, Constance Wang. There is no such policy memo present. I don't know who knew what, if anyone did, if people merely got paid particular enormous sums of money. Some of them may have been in the dark and mistakenly believed it was a bonus. In order to set Sam Bankman free, he had to have a good idea of what he was doing. You have to question how many other people were in the know as well. Furthermore, it's revolting. This $2.5 million yacht, along with all the other money we know about, had to come from somebody. It's quite awful that some people are spending $2.5 million on a yacht when that sum represents all or most of their life savings. Anyway, I'm just glad that things seem to be turning around for the better now that SBF and Caroline have finally had their comeuppance. These people. Can we all agree that these individuals are lowlifes? They're nothing but lowlife filth. Since there are still skeptics who refuse to believe that justice will be served, I'll simply reference the SEC v. Ripple case to demonstrate that no judicial system is foolproof. But at least in America, it has been effective. At least, usually. Things can go wrong in any system, in my opinion. That much has always been clear to me. However, in the big picture, things are looking up. And I have faith that SBF will spend a very, very, very long time behind bars. And it appears to be heading in that direction. No, I don't give out financial advice. Nothing I say should influence your buying or selling decisions. We appreciate your listening. Give the video a like if you found it entertaining, and if you want to see more, click the subscribe button. See you later, bye.